Great. So it's 12:01. It's Monday, October 18th. It's Albany Law School, First Mondays. First Mondays is an opportunity as a community to gather here in person, as well as folks online too, over Zoom. And I see a number of you are there. Some of our First Mondays regulars, as well as some new folks too. And for those who are joining, we'll get going. So First Mondays is an opportunity to delve deeply into a business law or to a business or political issue through a legal lens. I'm Professor Ted Barbieri, and I'm going to introduce my co-conspirator, Professor Pat Reyhan, to introduce today's panel.
Thank you, Ted. As Ted indicated, our goal here is to take issues in which there's been a whole lot of heat and try to shine some light on the issue, which there's been political heat on all kinds of sides, and yet the law has something to say. And the law has something to say that we as lawyers should know. As I mentioned in my email to many of you, even if we're not practicing in this area, there's certain things that we, when we hold ourselves out as lawyers, ought to know a little something about. And this is one of them. So our subject today is immigration policy generally, most specifically, the most recent crisis involving thousands of Haitians who gathered on the southern border of the US. And in order to put this particular narrow focus, and using this narrow focus as a way to talk about how persons are allowed entry into the United States, using Haiti as the lens through which to look at that is really important, because Haiti, as those who have studied it know, is almost completely a failed state. You can have a lot of discussion about whether people flowing north from the South and South and Central America are truly fleeing horrible situations. You can have that discussion. You cannot have that discussion about Haiti. Take a look sometime when you get a chance at an aerial image of Haiti and the Dominican Republic, two parts of an island, two countries that share an island. It is very much like looking at pictures of North Korea and South Korea from space. I don't know if you've seen those where South Korea is all lit and North Korea is all dark. Look at the contrast. Haiti has been for centuries the target of natural, economic, and political disasters. And there is no question about that. There is also no question, however we want to judge it, that the United States has been part of the creation of some of those disasters. So that gives us a way to look at that question in perhaps the starkest terms. Many of the people who came to the southern border are Haitian, but they have not been in Haiti since 2010, when a massive earthquake basically wiped out life on that country. Some are coming because of political violence, some because of economic despair. You get the whole range of human experience. So we have three experts here to shed some light on what the law says about this situation. We have Sarah Rogerson, director of our Justice Center. We have Lauren DesRosiers. Did I get it?
Great.
Close enough. Thank you. Who's a staff attorney in the clinic. And we have Professor Alexandra Harrington, who is going to give us the international side of things. So as I understand it, you two will be looking at some domestic law, and Alex will be looking at the international perspective. And like all First Mondays meetings, we have absolutely no plan beyond this. We just throw people deep in the water. They will talk, you will ask questions, and hopefully have a robust discussion. Who would like to start?
I can kick us off. I'm working with this microphone. It's working. So if you can give us a thumbs up on Zoom. Got thumbs down. Thumbs up from how? Okay, great. I was trying to find a poem that I actually heard at a protest on Friday. And it was spoken word delivered by a woman who goes by Dee Holland. She also happens to be running for Rensselaer City Council. And she also happens to identify as someone who is Haitian. And it was a poem about me. And it was entitled "We're Over It." And it was, I I'm so sad that I can't find it published anywhere yet. One of those spoken word opportunities that are fleeting and rare, but deeply meaningful. And the complexity of this issue, and I just want to elevate, and I won't address it, but what she was saying is that Haiti is more than its struggle. Haiti has a deep tradition of resistance, of strength, of original democracy. And so I just want to frame our comments by recognizing the Haitian influence, not only to our culture, but to the world, really. And sort of framing the tragedy through that lens, because it is tragic. When we make decisions, I should say, specify, when the government makes decisions about who to include and who to exclude, and on what basis they're making those decisions, it's usually political. Our immigration policies have been political from the beginning, and increasingly judges on the federal level are actually recognizing the racist origins of our immigration laws. The first being, among the first being the Chinese Exclusion Act, which literally on its face is excluding a group of people on the basis of national origin, okay? We don't talk about that enough when we're talking about immigration issues, but increasingly, it's so bad now that judges are actually recognizing that as a part of the legal history of immigration in our country. So with those two sort of like really heavy openers, I also sort of want to raise the questions for you, some questions you might ponder while we're talking, and in addition to all the questions that you have. And for those students that I have not seen in person because of the pandemic, hello, I'm so glad to see you. But I want to situate this. I'm excited that we'll have this international perspective and focus. Keep on pushing the button here. I'll try that. I'm excited that we'll have this international perspective and focus, because it's also a stark reminder about where these laws began to begin with, what a refugee actually is, what asylum actually means. Lauren has been prolific on some of these distinctions and maybe can speak to the difference between refugee and asylum. And I guess, I'd like for you as a framing question to think about this idea of who we include and who we exclude, okay? So it's very easy to get lost in the laws, right? Our laws refer to migrants generally as aliens. We're trying to get away from that language, but like when that's the legal framework that you're working with, it's very easy to get lured into that concept. So think about our remarks in terms of community, in terms of, for some of you, this might be a very personal issue. And for some of you, maybe you haven't interrogated your own family's immigration history, but it's never too late. And it does help you view this issue a bit differently, because it is personal. There is no law in immigration that is not personal. Migration, by its very nature, is a personal act. So we'll go into the law more as opposed to all this framing that I'm doing for you, but I wanted to set that up because I think it also changes the nature of the questions that people ask and how they ask them. This has become a controversial topic in our country for reasons that are mostly political and intentionally divisive. And I really hope that we have that we show that there's a better way to have this conversation today. With all of that being said, what actually happened at the border has to do with what's called expedited removals, and lots of different ways that we remove people from this country on an expedited basis, largely without any due process of law whatsoever. And by any, I mean definitely no judge involved, right? There's not a judge that was involved in any of these processes in any way whatsoever, remotely, in person, no judges reviewing, and no reviewability by a judge. These are determinations that are made by people who are trained to exclude. that being Customs and Border Patrol largely, and the Department of Homeland Security, which didn't exist until after 9/11. Another important framing point, which the older I get, the more important that point becomes, because there aren't even any TV shows anymore with the old INS jackets. There used to be, sometimes you can catch an old Law and Order episode, but like INS, the Immigration Naturalization Service, doesn't exist. So these are all things to think about and ponder and consider, and I should probably stop there because I know you're going to have lots of great questions.
Lauren, would you take it?
I'm gonna hold your button.
I feel like, yeah, I need a little.
Yeah.
No, I think it's like a
Okay.
little bit of like a workout.
Yeah.
Like getting some more workout here.
You can do it there. You can also talk from the lectern if you feel more comfortable.
You know, it's Monday, so.
That works.
Hi, everyone. I'm Lauren DesRosiers. I am a staff attorney with the Immigration Law Clinic, and I get to work with Professor Rogerson. And I'm really happy to be here. I think what I would love to talk about a little bit is the framing of asylum and refugee law in the US today. And then I think Professor Harrington can talk a little bit more in detail with her intense expertise about the international aspects and the treaty obligations that are really inherent in the underlying basis for asylum law. So asylum and refuge is a concept that really took off and became part of our law in the 20th century. It wasn't until the latter half of the 20th century that we actually had laws in place in the US that protected the rights of refugees and asylum seekers. In 1967, the US finally joined the UN protocol to protect refugees, on the rights of refugees. And it wasn't until 1980, 1981, 1980 or 1981.
You're getting a head nod from the international scholars, so you're good.
When the US actually codified those obligations in the Refugee Act. And so under those obligations, the kind of statutory definition of an asylum seeker and somebody who has the right under these laws to seek asylum is somebody who has either suffered past persecution or fears future persecution on behalf of a number of protected characteristics, including race, religion, political opinion, or membership in a particular social group. And their government is unwilling to protect them. And so if you meet that definition, you meet the definition of a refugee. The distinction between a refugee and somebody who is seeking asylum is simply a matter of location. So if you are outside the US and outside of your home country, you qualify as a refugee, and you will go through, if you are seeking refugee protections in the US, you'll go through a particular referral program that will allow you to come to the US and be resettled through refugee resettlement. However, there's another way to go about doing that, and that is to either seek asylum in the US or at a port of entry. What has happened now, and why I kind of want to bring this up, is because the people who are seeking asylum along the southern border, people from Guatemala, from Nicaragua, from Honduras, from Haiti, from Venezuela, from African countries who come over on ships and are forced to seek asylum at the southern border, they are all subjected right now to a number of regulations that have been imposed over the past 4 or 5 years that are designed to prevent people from accessing those benefits to seek asylum that are protected by US law and international law. So there are 3 programs that have kind of gone into effect. The first one was a metering program, and that was actually predated the Trump administration. And it was designed because there was an influx of people seeking asylum and protection in the US from Haiti. So it was designed and began to be implemented in November of 2016 under the Obama administration. because there was a concern about the rising number of people from Haiti seeking asylum. The metering program is basically a waitlist program. It says, we got 10 asylum seekers today. You can't present your application. We won't hear it. Come back tomorrow. That got instituted very deeply in the Trump administration and became really formalized. And people had to go up to a port of entry, put their name on a list, and wait for their number to be called in order to present their asylum claim to CBP. That was not a formal list. It was not administered by the US government. It was literally administered in Tijuana in a spiral ring notebook. The second program,
Mic drop.
The second program is the Remain in Mexico program, or the Migrant Protection Protocols, MPP. That was a program.
Yeah, your thumb gets tired.
Yeah. Okay. So the Migrant Protection Protocols were a program that was designed to deter people from pursuing their legitimate asylum claims in US immigration courts. So normally what would happen is, without metering, somebody would come to a port of entry, they'd ask for an asylum, or they'd ask to seek asylum, say that they feared, persecution, and they would be given a credible fear interview and then placed in proceedings where they could present their claim to an immigration judge. That would happen on US soil, potentially in immigration detention, but potentially they would be released from immigration detention. Remain in Mexico was a program that required people to pursue their asylum claims in US immigration courts while they were living in de facto refugee camps in Mexico, where they were not afforded any protection from either government, either Mexico or US. There were numerous reports of people being subjected to horrific violence in these camps. People who were very vulnerable were not afforded any protection. They were not allowed into the country on numerous occasions, despite specific exceptions in the program that were designed to allow them protections. And I'm talking transgender people who were subjected to extreme violence in these camps were not allowed to enter the US. And so the entire program was designed to deter people and prevent people from pursuing their legitimate asylum claims. CBP, there were numerous instances of CBP refusing to transport people to their legitimate immigration court dates because they were told that they were not real court dates or that the court had changed dates. It was a really horrific program. The Biden administration has attempted to wind down that program, but the Supreme Court refused to stay a district court holding that requires that the program be continued. The Biden administration is now being forced to continue that program. They're trying to wind it down, but it remains in effect today. The third program is Title 42. And Title 42 began during COVID. Title 42 is not an immigration statute. Title 42 is a public health statute. And at the beginning of COVID, on March 20th, 2020, the Trump administration began this policy that expelled migrants who were trying to enter the US to seek asylum, expelled them back either to Mexico or their home countries with no due process, no hearing, simply putting them on flights, putting them on, just expelling them from the country. This is what a number of the expulsions relating to Haitians are based on. Title 42 is a public health measure that allows the government to exclude people who they fear have some sort of public health, like disease or a risk to the health of the American public. And because of this, even though CDC scientists repeatedly said that this program was not actually going to help anybody related to COVID, it is forming the basis of an ongoing program that the Biden administration continues to advocate for, and which is continuing to expel people, including the number of Haitians that so recently were in the news. My arms are quite tired now from holding this down, so I'm going to pass the mic on to Professor Harrington.
I have something to look forward to. Oh, no.
Oh, there it is. There we go. Okay, thank you. I was gonna say, I'm going to cheat and use a pencil. There we go. Look at that. Okay, we're letting this pencil that I ever knew existed. So actually, one thing I want to follow up, I think we'll start with the Title 42 because it just flows really well. Notice the idea that when we're sending people back, I'll talk about non-refoulement in a minute, but when we're sending people back, we're sending them back to a country. And one of the ways that the US has actually gotten a lot of displeasure and ire from many people in the international community is by sending people back when they are potentially, theoretically, on a legal basis, exposed to COVID or potentially have COVID and are carrying it, and yet are being deported back to countries which typically do not have the resources to handle COVID as well as we do. And we obviously have had even stretch resources ourselves. So that's just one particular element that I think often gets lost in the discussion, is that we are, for many reasons, angering a number of countries within our certainly geographic community, and this is one of them. The other thing that is fascinating about Title 20 or Title 42 is that it has been kind of roving in the sense that at certain times it has been applied against people from China, people from various parts of Europe, especially Italy in the beginning, and various hotspots throughout India, for example, various hotspots throughout the pandemic. The one place that it has never been applied and then removed when the threat seems to have been moving on is the southern border. And so it is really striking that there's been no attempt by any administration to use it and then limit the use as an immigration tool, because it really has been used as an immigration tool under the guise of public health in a way that makes us often really need to think how we have public health in our discussions from a legal perspective. To go to kind of the origins, the international law origins of refugee policy and statelessness policy, we need to kind of wind back. And many of you are my students, and many of you will know where this is going. We need to wind back to the end of World War II, because this is where most of our modern policy really comes from, in this idea of after the war, so much has changed. And so many ideas that we now think of as human rights have emerged as basically essential. But we also have a number of people throughout the world, because this was a global war, who were displaced and who were refugees, who were in other places because they had been in concentration camps, because they had to flee, because the country that they were in no longer existed. And the question was, where do we go with these people? How do we get them back home? How do we reestablish their lives? The intent wasn't necessarily for them to stay where they were. The intent often was for them to go back home or try to go back home. And with that in mind, we see the initial Refugee Convention from the early 1950s, and then moving into the protocol, which is referenced in the 60s, which started to understand a more nuanced version of immigration and the idea of seeking refuge, but which didn't fully appreciate the various types of migration that were emerging as a pattern. And we saw a number of trends coming up, including the idea of statelessness. And statelessness is something we don't often talk about. We need to talk about, especially in the concept of Haitian communities at the southern border. And I'll explain this in a minute, but statelessness is the idea that you cannot be claimed by a state. You cannot claim citizenship in a state, and no state has an ability to claim citizenship protection over you. If you think about that for a minute, it should be truly terrifying, because it means that you do not have the right to a passport. You do not have the right to any place to verify your identity, to give you papers, to allow you to work, to allow you to go to school, access healthcare, anything. You technically don't exist. And when you don't exist, it is very easy for you to become very vulnerable. And so we do have a convention and a protocol on statelessness, and we are a party to it in the US. However, it often is ignored or it's often just not discussed. And when I mention it in the context of Haiti, I mention it because a number of those who we saw at the southern border were of Haitian descent or Haitian origin, but had been living in Chile, had been living in central parts of America. And when they came up, some of them had not been living here or in Haiti for a very long time. Some of them were children whose parents are Haitian, but were born in other countries. And Haitian nationality law is very blurry. It's established under the Constitution, their Constitution, but it is very blurry. And it is very blurry regarding those who are born outside of the state, even to Haitian parents. Theoretically, if you can prove that one of your parents was Haitian, you can be registered, but you have to be registered, which means you have to feel safe enough to go to an embassy that keeps proper papers, declare the birth of your child, and then have a piece of paper which says that this has been properly registered. Often these things are very hard to have, and often it's very difficult if you're in a rural area to make a trip, for example, to Santiago, the capital of Chile, to register this. And if you don't have these papers, you don't exist and you are not a Haitian national, which means that you will be returned, theoretically, to a country that you are not a national of. And you run the risk of being stateless, especially because the laws in Chile are very different and it's very difficult to achieve statehood in Chile if you don't have a Chilean parent. The same is true in most of Central America. So you have people who are potentially rendered stateless if they don't have some type of asylum or refugee claim granted to them and essentially don't exist. And in the concept of children, this is particularly hard because they are very vulnerable, we know, to trafficking. They are very vulnerable to especially sexual exploitation and sexual abuse. And if they are without their parents, it becomes a very difficult situation. The other concept that is a human rights law concept, there you go, I see what you mean by your arms. Yeah, it's a human rights law concept, I'm just talking about the arms now, as well as a refugee law concept per se, is the idea of non-refoulement. Now, those of you who took human rights last semester, you will remember the idea of non-refoulement, which is that under a number of conventions, so not just refugee and statelessness conventions, but also under various international covenants that set out like the really core principles of international human rights law. If you are seeking refuge or asylum in a country, and you can make at least a decent claim that you will be subject to public or private violence or retribution when you get home. So retribution by the state if you fled, but also by, for example, private mercenary groups. Then the returning of your person to the place that you have fled is illegal because it will likely result in a human rights violation. So while, for example, the US would not have to keep someone from Haiti if they could establish this claim, they could not return them to Haiti either. And you would have to find another country that would be willing to take in the person. You cannot return them back. One of the issues that we saw with the plane rides in particular, people, planes full of people being brought back to Haiti, often not being told where they were going when they were put on the plane, but just being put on the plane, is that when they were returned, they have been subject to violence and abuse, both by state officials and often by gangs and local actors. Many of you will have heard overnight or this morning that a number of mercenaries were, sorry, missionaries. Really good job. Missionaries were abducted by quasi-mercenaries, there you go, by armed gangs in Haiti. And this is a very common occurrence, especially if they know that you have been outside the country, because there's a potential that you will have something of value on you. Now, most likely that is not the case if you have just been returned, but that is not known to armed gangs, and armed gangs will use this as a reason to target people who have been sent back. And what we have is a very difficult position, obviously, for those who are in the middle of this. We also have a legally very suspect system from the US in the international law perspective, because we are at the moment violating a number of aspects of international law, of our treaty obligations, of our customary law obligations. And these are things that we hold other countries accountable for. These are things that we constantly criticize other countries for violating as well. They should be criticized. But when we then do it ourselves, it calls into question, especially from a legal perspective, how do we stop this? And how do we make sure that we are a system that operates on our own international law requirements, as well as trying to get others to enforce them? So I'm sure I have talked more than enough, and I'm sure that my finger will probably fall asleep soon. So I will stop talking, but we welcome all of your questions. And thank you both for organizing this, because it really is so much fun.
Thank you. Do either of you like to make a comment to what Alex has said?
I'll just add one point that I think is important to understand. Even during World War II, we were requested to receive Jewish orphans that we had credible information would be targeted for extermination in the Holocaust. As a country, we did not do that. And in fact, our Congress explicitly said that they wouldn't. If you read the floor testimony of the people who testified on the floor of Congress saying that we shouldn't do that, it's horrific. The Holocaust happened. And finally, it was Lyndon Johnson, do I have my presidents right, who said, you know what? This is morally reprehensible. I don't care what we decided in Congress. We are going to bring in these children. And then what happened to them was pretty awful too. So, there's a lot of problems here, but that is a really important thing to take note of, is that even as these conventions were being developed, we were forced to take action by the mass destruction of human life. And I really don't want that to be the next thing that causes us to change, because every mass destruction of human life that has happened since, including 9/11, has resulted in stricter immigration laws, not less restrictive. And so anyone whose family has migrated prior to the 1920s, I guess would be safe to say, has not been subjected to any of these laws. None of them. They didn't exist. And I think that's a really important point. We're about to head into Thanksgiving. If you have conversations with family or friends, these are things that just the American people don't know. And we need to, or else we're going to learn the hard way again.
Thank you. I'm going to take the moderator's prerogative and ask the first question, if I may, give you a chance to gather your thoughts as well. It seems to me from what all three of you have said, and particularly with the definition of asylum, that we have this problem we did have during the Holocaust, that there were so many people who were in the same circumstance. Now, in the Holocaust, it was government created. In Haiti, it's somewhat government created, but as our ambassador who resigned based on the US policy of sending Haitians back has noted, there's a complete breakdown of a social contract between the Haitians and their government. So in a strange way, unless you're stateless, all of these people are at the border are in the same boat. And I wondered, probably an unfortunate reference, but in the same situation. And that creates problems for them, but it also, I assume, creates massive problems for US immigration policy and border control and that sort of thing. So I wondered if any of you could comment on this very bizarre thing, that the more people are impacted by terrible situations abroad, the less likely they are to receive asylum here.
I'll kick us off just by saying, if you look at pretty much any sort of immigration policy that's been erected around a particular crisis or country or development, we seem to manage it pretty well. People come in through, I don't think we manage it well, but we manage the influx of folks because we have infrastructure to do that. We're constantly bombarded with messages that say we can't have more people in this country. And those messages are wrong. We've had a historically low refugee cap for a very long time. So we could actually have let in every single person that was at the border that was put on a plane back to Haiti into the country to pursue their claims within the country, or Congress could have acted to create a special law like the Cuban Adjustment Act, for example, to allow folks to come into the country and then get a green card and then get on the path to naturalization, which is what a lot of people who come to our country are looking for. Not all. Some never naturalize because they care so deeply about their home country that they can't imagine leaving their nationality behind, even though they had to leave their country. I know some of you probably feel that way about this country. So it's interesting and to look at all those other examples and say, well, what's different about the Haitian example?
Thank you. Lauren or Alex?
I would just absolutely agree. And so many of you know, my husband came from Laos on a very similar program in the late 1970s, early 1980s. And that program continued for a very long time. It was very well structured through Thailand and then the Philippines and then to the US, which really does beg the question, if we were able to do that for one country, and it was very similar in many others, years ago, decades ago, why are we unable to do that now with the sophisticated processing systems that we have, with the knowledge that we have, even how to build refugee camps in areas which are much safer and much more secure? And we do have that. There actually are entire architectural genres of how to build refugee camps. Why can't we incorporate that when many other countries have? And it really does raise some very frightening concerns about the priority for who becomes American and how they become American.
I'm going to be very quick because my arm won't last. But I do think that there's a very uneasy relationship between US foreign policy priorities and the immigration system, and how, as Professor Rogerson mentioned at the beginning, how the US prioritizes people and who they let in. And I think that particularly in Haiti, Haiti has a very unique history in Latin America in being the first freed slave state through revolt, and was subsequently punished through international law and policy in a way that echoes some other countries as well. And the US was very much part of that program. The US has also not been the shining benefactor for a number of countries that it has also now deprioritized immigration from. And I think it's really interesting to look at how the relationship between what countries the US prioritizes immigration from and which one it deprioritizes from aligns with those political foreign policy preferences.
Thank you. Who's got a question? Sir.
Well, thank you all for this lecture. It was very effective. Haiti's history, as she mentioned, since independence in 1804, has been very much, if I may say, destabilizing, with various nations, including France, its former colonial master, Germany and the US, intervening in Haiti over different occasions when it benefited their interest. So looking at Haiti today, do we consider it under international law as a failed state? Secondly, you also spoke about the US's behavior in international affairs, where it partake in the formulations of laws, but never or usually doesn't participate in the implementations of those laws. We saw the US was very play a significant role in the formation of the League of Nations, but it never was a member of the League of Nations, and several other international laws. Do we think that the US's attitude of, playing a role, condemning other nations when they don't implement these laws, but then only implement laws that, benefit the US economically? Do we think that sets a good example? Do we think, why do we think China, Iran, Saudi Arabia, African nations, South American nations will want to see the US as a leader or role model if this is how the US behaves, or has behaved historically?
Who would like to take that?
I think that was me, so my arm will fall off. It's good. We can rotate the arms. So I think, first of all, to the failed states question, it's never a designation you want to make. It's never anything that anyone wants to say yes or no definitively. I do think at this point, especially based on the recent assassination of a seated president, and then the announcement that there will be no elections for the foreseeable future, combined with the inability of the Haitian military and the Haitian police to maintain law and order throughout most of the country, I do think we really are at a point where it could be classified as a failed state. The closest analog to that is Somalia, obviously, because Somalia broke into governed at this point, and some of them are very effective, some of them are not. We do have a government that theoretically would be representative of Somalia if it could be unified, but at this point it is not able to do so, and we may have the same meeting at some point. Whether we call it that or not, we do need to, from a factual point of view, look at what goes on, and what goes on the ground really is first and foremost a threat to human rights and to life. And before we classify anything politically, that is what we really do need to remember at the end of the day. Certainly from the international human rights law perspective, we're trying to protect is the idea of human rights. And just the essential ability to live and to raise your family and be free from some type of violence. So I would say it probably is a failed state at this point. But whatever we call it, we need to make sure we don't lose sight of what those key issues are. In terms of how we're viewed, I think that certainly having spent the past several years in Canada and traveling to various conferences where the US was not well represented, especially in the climate context, we have lost a great deal of clout, and we do continue to do so when we don't sign on to treaties. The League of Nations was an excellent example. The Rome Statute for the International Criminal Court is another one. The Convention on the Rights of the Child, which every other country has signed on to. The Kyoto Protocol, which was the predecessor to the Paris Agreement on climate change. All of these are things that we were leaders in creating, but then we didn't sign on to. And with each one of those, it does call into question why we should have a seat at the negotiating table and how seriously our words should be taken and how seriously our views should be incorporated. So the more we conduct that way, the more difficult it is for us to continue that position. And the more difficult it is to ask any country to take us very seriously and to start giving up things in a negotiation process, which can be very fraught and very politically difficult when there's a question as to whether we will honor our end of the bargain.
Thank you. Yes, Jean, Ms. Kim.
First of all, thank you so much for hosting this event. It means a lot to me because I'm a Korean national who's been living in the US on visa for 10 years, and my grandmother is from North Korea, and I grew up partially in Geneva, Switzerland, and I have watched former Yugoslavian Bosnian refugees coming to Switzerland, working at small shops, and also I watched the 2016 Syrian refugee crisis happening and coming to all the refugees coming to Europe, and how the Switzerland and UN taking those issues. So I'm taking this topic very seriously, and it means very personal to me. And I am very interested in knowing your answers to my question. So my question is that I think that there is it's my observation that most migrants are hardworking and refugees are very hardworking people, but they are, I think I tried to compare the 2016 Syrian refugee issues with this Haitian issues. I think one of the biggest difference is that it's in the US, like most likely Haitian will come to US than Europe. And another part is that there is COVID, and there's a rising xenophobia due to that. So I think most migrants that I know don't want to expose, refugees or like stateless people do not will to expose and reveal their status because they're afraid to be deported. Those who are here or even those who are outside. And this morning I read the news that Haitian, a lot of people there's a rising number of people are kidnapped in Haiti. And I'm definitely sure that there are people who are internally displaced and recognize the IDP in Haiti. So I wonder why there's a lack of discussion between business, private sector side and the legal professional, because I think that people who are here or elsewhere as refugees, they start working in small shops and they're subject to like exploitation by employees and blackmailing or sexual abuses as a woman or even as a man as well. So I'm just wondering why there's a lack of dialogues opened up between business owners or private sectors and the side of public sectors and leaderships and law.
It's a great question. Let me turn it just slightly in a quick comment. We're at 12:47. I know many of you have class, including myself, so we'll go 3 to 5 more minutes and then we'll stop, and those who can stay, please do. It's a fascinating question because we simultaneously hear about the fact that everyone is hiring and there's no workers to work in the job. And then we see people who traditionally are desperate to work wanting to come to this country and not being admitted to the country. And so your question is so interesting as to at what point will people step back and say, hey, we could actually make a dent in both of these problems by working together. And I wondered if the columnists would like to, the panelists would like to speak.
Yeah, the Afghan refugee crisis, which was the crisis that immediately preceded this one. When you say the current immigration crisis, it's always like what happened in the last 3 days. Yeah.
Sorry.
No, that's okay.
No, I'm thinking about Haiti, but you could think of Afghanistan.
Yeah.
You could think of the last few years of
Right.
workers trying to get here.
But in the Afghanistan experience right now, which is evolving constantly every day, there is a more deliberate effort to match employers with individuals who have certain skill sets, but that's because these are people who were quote unquote our allies. So we have some sense of their skill set because a lot of the people who were evacuated worked for our government. And so that sort of, it hasn't worked well, but in theory, that would make that process a little smoother, right? I also hesitate to use the labor framework because when that happens on Capitol Hill, then the groups that are excluded are often other deserving groups of individuals that aren't seen as good labor, right? So I think there's a tension there that you're identifying between sort of like a labor-based system or humanitarian or family-based system that's inherent. But you're right, it's like a very solvable problem and we just haven't found the matching mechanism.
I just want to add on to that. Our immigration system is so siloed that we have these 3 buckets. We have labor-based or employment-based, we have family-based, and then we have humanitarian-based. And unless somebody falls specifically within the bucket of immigration that is so narrowly prescribed by US law, it's hard to get them to get status through that way. But you're right, there's so many overlaps in the way that things go. And as Professor Rogerson mentioned, a lot of the times immigrants are narratively in the way that the public imagines them pitted against each other. So they're deserving immigrants versus people who may have criminal convictions. And I just want to, lift up that a lot of the anti-immigrant rhetoric tends to lump everyone together. So one example of this is the anti-immigrant rhetoric in the previous administration that banned a lot of immigrants and prohibited a lot of people from coming to the US, affected our healthcare system in that there were a number of people who had surgical degrees or nursing degrees who were unable to immigrate to the US, which affected our kind of overwhelming lack of response to COVID and has resulted in understaffing in a number of areas. That problem kind of like pits like the educated deserving immigrants against kind of like other types of immigrants, such as like refugees or people who have been trafficked or who may be victims of crimes, who are also kind of deserving of protection and the kind of like right to live well. So it's a very complicated system that is so siloed in the way that it works that it can be very difficult to get out of that framework.
I'm going to call things to a close. Please, if you have more questions, if you can stay or we can go outside, that'd be great. I'd like to thank all of you for coming and all of you who came remotely. I'm sorry didn't get to the question in chat. We didn't get to questions here either. I'd especially like to thank the three panelists for bringing light to this subject. See you at the next gathering. Thank you so much. Thank you so much, Lauren.
Yeah,
Exactly. But,
How are you? Good.
Yeah, great.